However, I imagine there may be some charitable organisations that do perhaps care for someone who maybe is otherwise considered wealthy.
Do you
as part of the range of otherwise charitable purposes and activities they undertake?
The definition of charity and charitable purpose in the UK, is that consistent? I mean, we were told that, you know, this was based on 400 years of law, which ours is, the same basic laws. Is this definition consistent with how you would assess?
Largely, that seems to be a somewhat modernised restatement of the Statute of Elizabeth type purposes.
Do we need to modernise the statement here so people can understand it? Because obviously, if what you're saying is correct, then Father Lucas may have it wrong. Does that not say that the education role of the taxation department needs to be either upgraded or some other form of education needs to be in place?
Before you answer, can I clarify an aspect there which I think Father Lucas was actually talking about? He's referring to the word investments case, which has...
So you did hear it, did you?
I heard a snippet. So I did hear him talking about fee charging.
Well, let's hear the snippet you heard.
The bit I heard was he was talking about charitable purposes, but he also went on to talk about a fee-paying entity.
Yes.
So I think he was referring to an organisation which, under the word investments organisation, court case, could be considered charitable. Under that case, an organisation, say an aged care home for wealthy merchant bankers, retired, they could be set up on a fee-paying commercial basis. They could be considered charitable if they are giving all of their profits, say, to a charity. So this entity could be considered, under the word investments case, a charitable entity, even though it itself does not have charitable activities. I'm using my words carefully, but as long as its money is going to a charitable purpose, that is, it's being given to a separate entity, or it itself is undertaking a separate charitable purpose.
I agree with Mr. Roussell's comment, because he was talking about a tax effective structure.
And I think that's what he was getting at. I think he does understand the difference, and I'm pretty sure that's what he was getting at. So that would explain
I don't want to
you...
misrepresent what he said.
Yes, and I think I agree with Mr. Hardy in that we have very similar charitable purposes as defined in the UK and as they are applied here, but there is a difference with the charities and commercial activities because of the word investment case.
Yeah, I must say I'm still confused about how it was being put forward. So you're saying the merchant bankers can set up, they can charge a fee, and the profits can then be...
Sure. Can I explain the word investments case very quickly to you?
Oh, yes.
So we do, I mean, in this particular case, there was a funeral business being set up by a Bible society. I'm not quite sure what they were doing, but they were translating the Bible, so that they were considered to have a charitable purpose. But they had set up in effect, a fundraising arm, which was a funeral business, a fee-paying. Anyone could go and buy a funeral service. The money that was raised under that case would then be, or under that those activities are then put towards the word investments, the Bible translation activities. And under the word investment case, the court decided that the Bethel Funerals, the funeral business, was considered charitable because it's had a charitable purpose, that is, giving money to another charitable entity.
So it's the cross-subsidisation of commercial activities for the charitable activities.
But Father Lucas went further than that. He also said that looking after rich people was a charitable purpose as well as looking after poor people. And that's where I'm a bit confused, given that the statutory definition of charity that's used in the UK, where our laws emanate from, says that it's about the relief of those in need. Now, that is a different position.
I didn't hear his statement on that, but there may be services being provided that aren't in the context of financial need, that are in the context of other need, say spiritual need.
Yeah, well, I don't have Hansard on it yet, but it's reported in the media under quotation, so someone was monitoring it. And you know, that's the argument that, you know, if you're rich, you can still be entitled to charity, is a foreign consideration to me, I must say.
Without the benefit of seeing the transcript or the exchange, I couldn't comment.
Can I ask you then, when Hansard's available, to have a look at it and advise me what your view is on that?
Yeah, well, yes, I will, but as I said before, my first inclination is that a merchant banker's retirement home, on the assumption that the merchant bankers were all wealthy, was improbable to be charitable.
Mm. Yeah. Father Lucas also told the inquiry that an organisation shouldn't lose its tax privileges if its leaders turned a blind eye to child abuse. Is this a consideration of the Taxation Department?
I think that once again, it's agreed that child abuse is a criminal matter. Then, of course, the criminality questions are for the police. I think for an organisation, there will be many organisations where members of the organisation commit crimes, but it doesn't necessarily mean the organisation is criminal in its operations. And so while that will be something which we would perhaps have to turn our mind to in terms of considering charitable endorsement for tax concessions, just the fact that any particular member of a religion commits a crime doesn't necessarily mean that the religion itself is established on a criminal basis.
But if the leaders of that religion, are turning a blind eye to the criminal offences, isn't that a higher test?
That would certainly seem to be a higher test. Again, the criminality aspect perhaps would be that if the criminal justice system didn't feel that the turning of a blind eye was sufficient to secure some sort of criminal prosecution of those turning a blind eye, it's a very difficult position to put an administration of just a tax concession into the position of making that judgment call.
So can I just, the last question, in conclusion from me, the modernisation of the language that's happening in the UK and New Zealand and other administrations hasn't happened here?
No. Well, not to the extent. There have been some extensions in Australia.
And there is no legal impediment other than the need for COAG to deal with the establishment of a commission, to establish a commission if that's the desire or the recommendation or the political will of a government to try and implement it.
And more generally, I think, Senator, even separate from the issue of setting up a charities commission or not, to the extent that it would be desirable to replace, either to replace completely or at least in statute to set down now our current understanding of what the common law of charities is in terms of the definition of charitable purposes, etc. It presumably would be desirable for that law to be relevant not just in the Commonwealth's jurisdiction but in the Commonwealth and the state and territory jurisdictions, so that such entities were able to operate under a regime where what was charitable was the same in both state and Commonwealth jurisdictions. So, as I said, it's not just a matter of seeking cooperation with the states and territories if there were a decision to set up a charities commission. It would also be necessary to have the cooperation of the states and territories if we were seeking to develop a whole new statute that sought to define charitable activities and so on.
Sure. Thanks.
Senator Xenophon.
Just a supplementary to take for Mr. Hardy and perhaps and also for Treasury to take on board. In terms of an organisation that has tax-free status here in Australia, remitting money overseas to a head office, and we're not talking about whether its primary aim is to be a World Vision or Caritas or other organisations. where do you draw the line? Are there any guidelines in relation to that? And does Treasury, is there a policy position on the part of Treasury to say, you know, it has to be a reasonable amount if it goes overseas to the head office for their administration, that there must be some benchmark or some line in the sand?